cared about. I didn't realize how important it was in practice. Because in South Dakota, I think it's real easy to just trust our government. I mean, after all, whether we're talking about the city folks, the county government, or even folks that are employed by the state, they're people just like us. They're our neighbors, they're sometimes our relatives, it's maybe even some of us. And so we say, well, why worry about open government? There's folks at or near the pinnacle of power in this state that have been saying that as, rather desperately the last couple of years. Why are you worrying about open government? You know, they cross their arms and say, oh, there's nothing that you need to know. That reminds me of a Bushism. I think Bill Thompson sent me, I can't quote it exactly, but it was sort of George Bush assuring people that, you know, don't worry, there's nothing you don't need to know that we're not going to tell you. And a lot of times what's happened with the leadership, Republican leadership in tears, they just shrug their shoulders and say, well, nobody cares about it anyway. Who cares? Don't let them kid you. People do care. People care a lot about that. How do we know? Well, one of the best signs is in the last legislative session, there was kind of a race to elbow folks out as to who could carry that banner. And nothing made me feel better than to know that folks were kind of fighting over the right to be the standard bearer for the issue of open government. There were three pieces of legislation that I want to mention to you today, just to kind of bring you up to speed on the issue, especially those of you that are going to be candidates this fall. Last summer, the Attorney General's Task Force on Open Government, which is a bipartisan group, and it is for the most part not legislators. It's media representatives, some lobbyists, some folks from local government, just some lay folks that care about it. We all reached a consensus about what should happen with regard to a procedural matter, and we agreed on a bill that would set up kind of like a small claims court procedure, so that if someone, whether it's Nick Nemec or whether it's the Argus leader, wants information from a government entity that they can't get, that there's an abbreviated process that makes it easier, a little more people-friendly process to get that issue heard. Under prior law, you would have to actually hire a lawyer, really, and probably bring a lawsuit if you wanted to challenge the issue of whether a government was withholding information you should have. And by consensus, our study group, the summer task force, agreed that that would be a good procedure. In a bit of partisanship that I'm still just learning to anticipate, the majority leader in the Senate and the House sort of adopted that, called it their own, kind of in a way, it reminded me a little bit about, you know, what's the saying, failure's an orphan and success has a million fathers. Well, they embraced that bill and called it their open government bill. And you know, that's fine, I don't care who gets credit for it, but that bill passed both houses, and the governor signed it. So at least as of July 1st, we have adopted an abbreviated, more user-friendly process. If you have a question about government record or government information, you're denied it in a way that you think is unfair, there's an administrative process that will make it easier for you to access a resolution. The two other pieces of legislation that were more contentious, though, and I think are more interesting and frankly are going to keep coming back, are these. A bill called House Bill 1233, which embodied the saying that politics makes strange bedfellows, had me, so to speak, with Jason Ganton and Hal Wick, and I know that's those are strange. But you know, some good government and open government is important no matter which way you want the government to move. And House Bill 1233 would have made a very user-friendly, searchable website, part of the state's obligation. And a lot of other states have done this. It's just a way to make use of technology and try to get information to the citizens. Now, I'm not going to claim that that was a perfect piece of legislation. I'm sure that it wasn't. But the concept of it is an exciting one for anybody that cares about democracy, because the idea is that you can all just get on your internet at home, find out what's going on, who's getting this government contract, what's the government spending on this, that, and the other thing. Frankly, the reason that that I think fiscal conservatives embrace it heartily or ought to is because everybody knows that one of the first ways to discipline yourself is to keep track of what it is you're doing. I mean, you go on a diet, start writing down what you eat, and you'll eat less. If somebody comes to you with a financial crisis, a budget problem, first thing you want to know is what are you spending? Keep track of it. So it's really it's an exciting concept, I think, from the standpoint of responsible government as well as from citizen access. That open government bill passed both houses of the legislature and was signed, but was vetoed by the government. Came back and the House actually overrode the veto. The Senate failed to do so, and I think it was a 20 to 12 vote. But we had at least limited success, and now, of course, we heard the promise that there will be something coming next year on that. The third piece of legislation, which people can sort of call it my bill, but it really wasn't mine. It was the work of, it was shamelessly stolen from some other states. I think I used a lot out of Iowa, and I used a lot of thinking that came out of the summer task force. Would have changed the substance of our open government rule. You see, South Dakota is the only state that has a presumption that you as a citizen are not entitled to government information. It's kind of a crazy rule if you think about it. If you want to go into a government office and request information, you essentially have the burden of proof. Marianne and some of the other lawyers would understand. The burden of proof is on the person who's requesting it. You have to prove that you're entitled to it. And the first step in that is to prove that it is a record that is required to be kept by government. Now that's sort of a silly and irrelevant rule, I think. If government keeps a lot of records, and of course it does, and it's maybe required as a practical matter to keep track of government business, that's not good enough. You have to prove, under existing law, you have to prove that there's a place in the statute where it says that this board shall keep this record, or this agency shall keep it. If it doesn't say that, you're out of luck. So what Senate Bill 189 that had bipartisan sponsorship would have done would have been to change that to a rebuttable presumption of openness. To just embrace what 49 other states and the federal government all have, which is a presumption that in a democracy, you as a citizen are entitled to information unless the government can show there's some reason you don't get it. Now, there was a bit of a hue and cry because, of course, that's scary to those in power, to think that we really could turn the tables and have citizen access to information. But I think also there's some parts of resistance that, you know, if it's our idea, they don't like it, and maybe it'll come back, you know, down the road with somebody else's name attached to it. But the boogeyman that was thrown out there for the most part, the boogeyman was this, that, oh my goodness, all of a sudden your private information is going to be accessible to everyone. Well, certainly privacy is an issue we all have to care about anyway, but the idea that it was going to be sacrificed by opening up government records was nothing but a boogeyman. The bill that the Democrats supported, and we did have some moderate Republicans with us in the Senate, would have maintained the existing protections of confidentiality in the statute. In other words, if there's anything in federal or state law currently that says certain information is confidential, like your social security number, your medical history, certain information like that. Even if you have a concealed weapon permit, that happens to be confidential under South Dakota law. That was kept in place. Senate Bill 189 also added another category, or another list of categories of things that would be protected.